Marc Elias is a Democratic attorney who is the founder of the Democracy Docket. And we learned very recently from this article over here on Breitbart that he is now making a lot of the same claims that a lot of Trump's attorneys were making back in the election season. So we're not going to be talking about the old election stuff. We're only talking about this new litigation. So here it is. This is over from Breitbart. This was posted by Joel Pollack, who does just outstanding reporting. I can't believe that nobody else is covering the story. And he says, Democrat lawyer Marc Elias claims the faulty voting machines in New York race. Marc Elias, the election lawyer who represented the Democratic challenges to the state rules throughout 2020, alleged in a court filing this week that a close congressional race in upstate New York was marred by faulty voting machines, which is strange because we were told largely that just wasn't even a possibility. Republicans have been vilified. They're making similar claims about the 2020 presidential race. In the current congressional race for New York's 22nd district, Republican Claudia Tenney currently leads the incumbent Democrat Anthony Brindisi by a razor-thin margin of 125 votes. Tenney declared victory on Tuesday, though the challenges continue. So Republican versus a Democrat, margin of 125 votes. But in a legal filing on Monday, they are requesting a manual audit of the election. This is Elias, whose Perkins Coie law firm is representing the Democratic attorney, the Democratic candidate. They were arguing that there were, quote, substantial errors and irregularities in the conduct of the election, which is just outstanding, right? The Democrats are now suing in court saying there were substantial errors and irregularities. All right. But only in this election, only in this one race, okay? Because we know that Joe Biden and Kamala Harris are the legitimate, uniting presidents of this great country. And there's no contesting that. There's no evidence of widespread fraud. There's no basis for it, in fact. Only in this race, according to Marc Elias, because in all of his other lawsuits, he responded to all of the other ones. He not all of them, right? But a large part of them. You can go on the democracydocket.com and figure out which ones he was working on. But his firm was very influential in this thing. And they were responding in all of their pre-election lawsuits, or I would say pre-January 6th lawsuits, saying that all of this was completely by the books. Only now do we see that maybe in this one election, not so fast, right? This is Marc Elias. Let's do a little bit of background on this fella. He's a powerhouse of an attorney. He is the founder, as you can see here, of the Democracy Docket. Meet the team, along with Ali Rothenberg. We got Sam Gottstein, Kelsey Moskovitz, and Marc Elias. He's an American attorney specializing in election law, voting rights, and redistricting. He's a partner at Perkins Coie and the head of the firm's law practice. He went to Duke University Law School, Hamilton College, Duke University, and he's over at Perkins Coie. And if you take a look at his Twitter feed, he says, a lawyer fighting for Democrats and voting rights for all. The Democracy Docket founder, and his dog's name is Bodie. I think Bodie? Yeah, probably Bodie. Okay, about 450,000 followers, big influential guy. And I think that if anybody can be credited for changing the rules at this last election, it's this guy. Okay, we talked a lot about the election litigation leading up to the 2020 election. All of these lawsuits were filed around the country to change the rules with the legislatures, with the courts. Everybody was getting involved. COVID. There was, hysteria all over the place. Grandma's not going to be able to vote. Therefore, we got to change the rules at the last minute. And this guy and his company and this whole endeavor was responsible for that. Many people don't recognize how impactful he was. People are instead focused on Venezuela and Smartmatic, when really, folks, it happened here in the courts before the election started. This is and you can't say it's fraudulent at that point in time because the rules changed and he just was the one implementing the rule changes. And since the rules changed and the courts agreed that the rules were legitimate, it was to their advantage. So in fact, it wasn't fraudulent because they were following the rules. Now, the bigger question always has been, were those constitutional? Were those rule changes allowed? And the Supreme Court never weighed in on it. So here is Marc's lawsuit. They are suing the Oswego County Board of Elections. And so it's an elections, company here. Claudia Tenney is the petitioner suing against Oswego County Board of Elections. And we can see here, Marc Elias is admitted pro hoc vice in support of the proposed order. They're the respondents. Let's see here. All right, so these are the attorneys. Here we have it. The general election, when we start looking at the introduction, this was received on February 1st. The general election for the public office it took place on November 3rd, like many of the other issues. Since then, substantial errors and irregularities in the conduct of the election have come to light. Right? So in this one election, not in the presidential election, but only in this one, the 22nd District of New York, we are now seeing, according to Marc and his firm, substantial errors, irregularities in the conduct. As these proceedings have continued, that evidence is only mounted. In addition to failures to follow New York elections law, so on and so forth, there has been mounting evidence of significant irregularities in the tabulation of the ballots. Because the candidates are currently divided by a vote of a mere 122 ballots, these errors and irregularities threaten to deny voters the election of their candidate of choice. As a result, a hand audit is warranted under New York law, should be immediately ordered. Specifically, and in the language of the statute, there is substantial evidence which, quote, indicates that there is a likelihood of a material discrepancy between such a manual audit tally and such voting machine or system tally, or a discrepancy is defined in the subdivision. This creates a substantial possibility that the winner of the election, as reflected in the voting machine or system tally, could change if a voter verifiable record audit of additional voting machines or systems, or of all voting machines applicable to such election, were conducted. And they're referencing the New York Election Code. Okay, so they're basically making a case saying here that there were all sorts of problems, and the only way to fix it is through a verifiable record audit of the voting machines. In his own lawsuit in a 2020 November 3rd election. All right. The background here, that discrepancies between the number of votes cast and the number of votes tabulated have been pervasive in the counting of ballots for this race, made itself undeniably evident on multiple occasions during the second and third canvasses in Oneida County. At each canvass, affidavit or absentee ballots were opened and first counted and tabulated on the counting tables. According to this affidavit of Lucy McIntosh, Oneida, I think that's how you say that, then transported the ballots from the canvassing location back to the elections office for machine tabulation. However, most evenings, the results as manually counted at the canvassing tables were different than those tabulated on the Oneida County tabulation machines. And what are they using as evidence? An affidavit, right? And this is Oneida County. So is that what they said? Oneida County. Oneida County here used ImageCast, and they also used Dominion voting systems. This comes from Wikipedia. This is a label. This is an identification of all of the different counties in New York and what systems they use. You see some here, like New York County uses election systems and software and the DS200 ballot scanner, but in Oneida, they use Dominion. All right. Same machines that a lot of these other counties use. All right, here's what they're saying happened. On December 28th, the manual tabulation at the table resulted in 103 votes for Tenney, 50 votes for Brindisi, and 7 undervotes. But the machine tabulation resulted in 103 for Tenney, 49, and 8 undervotes. All right, so what are we looking at here? We're looking at different exhibits. We have another affidavit. Same story. January 27th, they counted some other ones. 133 votes for Tenney, 40 votes for Brindisi. But the machine said 133 votes for Tenney and 39 votes for Brindisi. And there were 9 undervotes, so they were off by about 1. Biased against Brindisi, the Democrat. January 28th, again, 77 votes for Tenney, 72 for Brindisi, 7 undervotes. But when they ran it through the machine, same number of votes for Tenney, but 71 for Brindisi and 8 undervotes. So you see what's happening here? It looks like 1 vote is being pulled away from Brindisi, and it's counted as an undervote, according to this McIntosh affidavit. All told, and this goes on. There's several more examples of this in the complaint. All told, there was a discrepancy of 9 changed votes during the second and third canvass of Oneida. They administratively rejected the affidavit and the absentee ballots alone. Oneida County then counted 1,127 ballots during the course of its second and third recounts. There was an error rate then of 0.8%. And they're just doing the math. We saw a lot of this same math in the litigation that we covered previously. 325,000 votes were cast, applying the same error rate of 0.8 to 325,000 ballots. There could be as many as 2,599 votes that the machines did not read. Even if the problem was with one tabulation machine only, around 100,000 ballots cast in Oneida, there may have been 800 votes that the Oneida County machines failed to read alone. That figure far exceeds the margin between the two candidates in this race, and based on this small sample size at least, it appears to disproportionately affect Brindisi. This is basically the same exact argument that we saw repeated over and over and over again with Trump's legal team. In addition to the table machine count discrepancies, there have also been procedural inconsistencies that question the integrity of the process. Exact same language. This was concluded by the counties. For example, November 24, 2020, respondent from the County Board of Elections provided its, quote, final numbers for the vote count to the 22nd district. 5 days later, however, Brindisi learned through a talk radio host that the vote totals had changed since the final tally because of, quote, incorrect numbers being transcribed in few election districts. Have you heard that language before? I have. We talked about it for, a month. Only after hours, attempts by Brindisi and his counsel to contact the board, did the counsel for the county advise them that the correction results in an additional 10 votes for Brindisi and an additional 35 votes for Tenney. So they're literally talking about the same issues that we've spoken about for a long period of time here. The argument goes like this: Brindisi is entitled to a manual recount. In this case, there is reason to believe that the voting tabulation machines misread hundreds, if not thousands, of valid votes as undervotes, and that these tabulation machine errors disproportionately affected Brindisi. In addition, Oswego County admitted in a sworn statement that its tabulation machines were not tested and calibrated in the days leading up to the November 3rd election, as required by state law and necessary to ensure the counts generated by the tabulation machines were in fact accurate. Second part of the argument, the court should stay its order directing the certification of uncertain results pending the outcome of a hand audit and a resolution appeals from its order. Since the court order directing the counties to certify its result is also independently justified by the pendency of appeals whose resolution could alter the outcome of the election, they're basically saying here, when an appellate court resolution of appeals could alter the outcome of the election, certification of the election prior to the resolution of those appeals distorts public perception of the election's outcomes and risks undermining public confidence in the process. What? I agree with you, by the way. I agree, Mark. I 100% agree. We're super glad that you have come around to our side of the argument. We're very happy. Welcome aboard. We all want election integrity. This is him signing off on it. He's on the motion itself. Marc Elias admitted pro hoc vice, signed on February 1st. Here's Mark's name. Okay. Along with a number of other people from Perkins Coie. Okay. I agree with him. I 100% agree with him. I basically agree with every one of his arguments. Wholly endorse this lawsuit. I think that they should get to the bottom of that in that particular county. See where it leads. He's pointing out some election irregularity. Let the Democrats go find it. I was saying this even prior to today. I was saying, I don't know why the Democrats aren't filing these lawsuits themselves. Trump was getting criticized for filing his lawsuits all over the place. I'm saying, well, there are other close races in this country. Maybe the Democrats could go peel off another Senate seat. Maybe they could go peel off a couple House votes, and now they're doing it. Yay, good, finally. They're looking into it as well. Let's see what the courts do with this. Is this going to be dismissed on standing, mootness, latches? We'll see. Don't hold your breath on it. And here's Mark. He's responding to it. I would follow him. He's a good follow. I think he's a brilliant attorney. I wish that the Republicans had their own version of him, but they just don't. He says, wow, you totally got me. We are seeking a recount in an election where the margin is 120 votes out of more than 300,000. So 0.04. And the National Review, they wrote an article on it. Of course, Breitbart wrote an article on it. And, I think in Mark's defense here, what he's arguing about a very, very small margin, right? It's 120 votes. It's not 80,000 votes like Trump was trying to move around, I think, in Pennsylvania. But it's the same allegations. It's almost essentially exactly the same. Same claims. Bad counting, hand audits are better, tabulation errors, procedural errors, everything is embodied in his own documents. Oh, boy. All right. So that's Marc Elias there for you.